call Andrew Little.
Thank you, Mr Chairman. I express my disappointment that at a time when the country we like to think is rapidly modernising, when in every other sphere of the labour market we are looking to diversity, we are looking to inclusive means to grow and nurture and develop the relevant workforce, this bill takes us backwards. It takes us back to an age of privilege, to exclusivity, to focusing not on those who may be the best legal minds, but on those who have the right connections and can persuade the right people at the right time to achieve the right appointment. And so, Mr Chairman, this bill might be better titled the Lawyers and Conveyancers Return to Exclusive Privilege Bill, or the Lawyers and Conveyancers Return to Inexplicable and Undeserved Exclusivity Bill, because that's what is happening with this. The legal profession is very important, and those who practice at its most senior levels, those who are most experienced, those who we need to retain, because, let's face it, many lawyers, many senior practitioners suffer the same temptations and are often offered the same blandishments as those in other walks of life, and the prospect of early retirement and one's twilight years on the golden sandy shores of various beaches of the nation, those sorts of things are very tempting, and yet they are people who have much to offer in the practice of law and in the prosecution of the very important role that they play in the courts of this land. And yet this bill will say we're now going to go back to a time when a small number of people, a small coterie of those who are the Attorney General and those who are close to the figures of the establishment and the government of the day, will select those who have chosen to go to what is, I think now, incorrectly named the independent bar, because the independence, at least in some cases, is open to question. Those who are in the independent bar will qualify, whereas those who are senior practitioners and excellent advocates in other parts of the profession, they will not qualify. And that is such a bad step. And we need to see in the legal profession, at a time when the legal profession itself is reorganising itself into a more coherent organisation, offering up better oversight and greater discipline amongst the profession, setting ever higher standards, this legislation will take us back to an age and an era that did not promote and encourage that. It promoted the rubbing of the right shoulders, that is to say shoulder to shoulder, not the massaging approach that might otherwise have been suggested by that turn of phrase. But those who, in the clubs, the gentlemen's clubs of the nation, who knew each other and knew each other well and could speak highly, often with the correct accent, nurtured by King's College or even Christ College and those elite schools of the nation, if they had those contacts and those connections, then they may well find themselves a candidate to be QC. And because of the exclusivity of the nature of the appointment, it gave them a market advantage. And that's what it was often seen as, a marketing advantage, and they could charge a higher fee. Well, that is not what we want to see in the senior ranks of any profession, much less the legal profession. And so that is why we need to see, if we are going to see true development and the application and the prosecution of the rule of law in our courts of justice, in our tribunals, we need to know that the people who are operating at the most senior ranks represent a diversity in New Zealand that we are seeing in so many other spheres. So that is why it is important that if we are going to have this bill, and it looks like there's an inevitability about it, that it properly reflects what is happening. It properly reflects the step that this bill represents, which is a retrograde and a backward step, and not one that is embracing of modernity and the modern approaches we would expect in a modern profession and a modern country seeking to fight its way and find its way through the world. So for that reason, sir, we will oppose this disappointingly and grudgingly as that may be, because it will not improve the profession or those who operate within, most importantly those who aspire to its senior ranks and to be the senior practitioners of tomorrow.
Chairman.
The Honourable Leanne Dalzell.
Chairman, I wish to participate in this part of the debate